The subcommittee will come to order. At the conclusion of opening statements yesterday, the chair called up the committee print, and the bill was open for amendment at any point. Are there any bipartisan amendments to the bill?
Mr. Chairman, I believe Manager's Amendment number 2 is a bipartisan amendment.
Does the gentleman seek recognition for the purpose of offering the amendment?
Yes, I do.
Very well. The clerk will report the amendment.
Amendment to the discussion draft offered by Mr. Welch and Chairman Burgess.
Without objection, the reading of the amendment is dispensed with, and the gentleman is recognized for 5 minutes in support of the amendment.
My understanding, Mr. Chairman, is that these are largely technical amendments, and I would yield to the chairman to give an explanation of the content of Manager's Amendment number 2.
I thank the gentleman for yielding. This amendment does make technical corrections to clarify language in the bill around who is covered and around publicly available language. Does any other member seek recognition on the amendment?
Mr. Chairman?
Yes, the gentleman from Vermont.
Thank you. If I could just ask a few questions of council to clarify some issues that have been presented to me by some of my colleagues.
The gentleman is recognized.
First question to council. Does this bill as drafted preempt state laws as it relates to privacy?
Mr. Congressman, no. The plain language of the text limits the draft's application to data security requirements and breach notification requirements.
Thank you. Second, does this bill preempt the Federal Communications Commission's ability to regulate privacy as it currently does?
No. Again, the plain language of the draft is specifically limited to data security and breach notification requirements.
And thank you. And number 3, specifically, does this bill preempt the FCC's ability to regulate privacy of and prohibit the disclosure of cable and satellite companies as it relates to an individual's viewing habits?
No. The cable and satellite providers would not be relieved of their duty under existing rules to not disclose a subscriber's viewing habits.
Thank you. And my final question, counsel, does this bill preempt the Federal Communications Commission's ability to implement the recent Open Internet Order?
No. The language of the draft imports the definition of common carrier from the Communications Act and applies it to this draft.
Thank you. I thank counsel for those answers. Mr. Chairman, I yield back.
The gentleman yields back. Is there further discussion on the amendment? If there's no further discussion, the vote occurs on the amendment. All those in favor shall signify by saying aye.
Aye.
All those opposed, nay. The ayes appear to have it. The ayes have it, and the amendment is agreed to. Are there further bipartisan amendments to the bill?
Mr. Chairman, I have an amendment I believe is bipartisan. It's Amendment 03.
The gentleman is recognized.
Thank you, Mr. Chairman.
I beg your pardon. The clerk will report the amendment.
Amendment to the discussion draft offered by Mr. Pompeo and Mr. Welch.
Without objection, the reading of the amendment is agreed to. The gentleman is recognized on his amendment.
Thank you, Mr. Chairman. Last week at the legislative hearing on data breach, there was lots of discussion about the proper party, about third-party notice provision that was contained in the base text. In particular, there were questions raised about which party should provide notice to affected individuals when a breach-covered entity who handles data for another non-breach covered entity suffers a breach. All 4 of the witnesses at the CMT's first hearing back in January supported a rule that the breached third party, should be responsible for providing notice under the bill. And then again just last week, we received written testimony and heard oral statements at the legislative hearing that the third-party notice provision of the discussion as drafted could lead to significant over-notification of consumers. Frankly, another benefit, too, is that we require all breached entities to have the same legal burden to provide notice after a breach, is that it provides strong incentives for all companies to improve data security itself in order to avoid having to make public notice of their breaches. I do understand that there are still some outstanding concerns with the amendment I'm offering today. I look forward to working with my colleagues to address any of the possible issues they might have before we move to full committee markup. I yield back, Mr. Chairman.
Gentleman yields back. Further discussion on the amendment? The gentleman from Vermont is.
Thank you. I think, Mr. Pompeo, this language is important and helpful. and with the assurance, too, that we're going to have an opportunity to further refine this language and make sure that it achieves the shared goal on third-party notification, and make certain that it doesn't have any unknown adverse impact on consumers or others. I fully support this amendment and thank the gentleman for his effort.
The gentleman yields back. Further discussion on the amendment? If there's no further discussion, all those in favor shall signify by saying aye. Aye.
Aye.
All those opposed, nay. The ayes appear to have it. The ayes have it. The amendment is agreed to. Further bipartisan amendments. Mr. Cardenas is recognized for the.
Thank you very much. I have two amendments, and the first one being on education and outreach.
The clerk will report the amendment.
I'm sorry, could you please designate by the language at the top? Is it?
Education and outreach, Section 7, education and outreach.
Got it. All right. Amendment to discussion draft offered by Mr. Cardenas and Ms. Blackburn.
Without objection, the reading of the amendment is dispensed with, and the gentleman is recognized for 5 minutes in support of his amendment.
Thank you very much. I appreciate the support by Congresswoman Blackburn and bipartisan nature of this effort. And the amendment is basically education and outreach for small businesses. The Commission shall conduct education and outreach for small business concerns on data security practices and how to prevent hacking and other unauthorized access to acquisition of or use of data maintained by such small business concerns. It's pretty self-explanatory, and it just, I think it'd be good practice for the Commission to assist those who need that kind of support. Thank you. I yield back.
The gentleman yields back. Is there further discussion on the amendment? The gentlelady from Tennessee is recognized.
Thank you, Mr. Chairman. I just want to thank Mr. Cardenas for bringing the amendment forward. This is an area where we can all agree it is important for the FTC to engage with small businesses who may be unfamiliar with some of the data security protocols, and I thank him for the amendment and yield back.
Gentlelady yields back. Further discussion on the amendment? If there's no further discussion, the vote then occurs on the amendment. All those in favor shall signify by saying aye. Aye. All those opposed, nay. The ayes have it. The amendment is agreed to. Further bipartisan amendments? For what purposes the gentleman from California seek recognition?
I have an amendment on website on data security best practices.
The clerk will report.
Amendment to the discussion draft offered by Mr. Cardenas and Ms. Blackburn.
Without objection, the reading of the amendment is dispensed with, and the gentleman is recognized for 5 minutes in support of his amendment.
Thank you very much. As Congress continues to work towards addressing preventative measures to secure Americans' data and cybersecurity, this bill is a step in the right direction. Also, it ensures that there's a standard of notification for all Americans. For example, in my state of California, we have a strong personal information protections, a trigger for notifications that protects all consumers equally, and much stronger notifications requirements, because when our personal information is at risk, we should be given as much time to protect ourselves as possible. And in that spirit, I think it's important that I appreciate the support once again of Congresswoman Blackburn on this amendment on website and data security best practices. The Commission, it reads very simply, the Commission shall establish and maintain an internet website containing non-binding best practices for businesses regarding data security and how to prevent hacking and other unauthorized access to acquisition of or use of data maintained by such businesses. I yield back.
The chair would ask the gentleman from California if he would be willing to yield to Ms. Blackburn.
Yes, absolutely.
Gentlelady is recognized.
Thank you, Mr. Chairman, and again, I thank the gentleman from California. One of the components we've discussed regularly as we've talked about data security and breaches is the need for public information and ready access to that information, and also for industry to work with the FTC in the establishment of best practices and protocols. So I thank him for the amendment and appreciate his diligence in his work, and I yield back.
The gentlelady yields back. Any further discussion on the amendment? Seeing none, the vote then occurs on the amendment. All those in favor shall signify by saying aye. Aye. All those opposed, nay. In the opinion of the chair, the ayes appear to have it. The ayes have it, and the amendment is agreed to. Are there further bipartisan amendments? Are there any other amendments?
Mr. Chairman, I have an amendment at the desk.
Gentleman from Kansas is recognized for the purpose of offering an amendment.
Thank you. The amendment is numbered 01.
The clerk will report.
Amendment to the discussion draft offered by Mr. Pompeo.
Without objection, the reading of the amendment is dispensed with, and the gentleman is recognized for 5 minutes in support of his amendment.
Thank you, Mr. Chairman. During last week's hearing, there was lots of discussion about some language that's in the bill, page 24, lines 6 through 10, that is bracketed language having to do with an exemption from the preemption provision for common law causes of action. During the data breach discussion, witnesses highlighted lots of concerns with the language that preserved a covered entity's liability under common law. This is very troubling. This is an open gate in the preemption language that I'm very concerned about. The inclusion of this language in the enforcement section that specifically states the private cause of action cannot be brought against a covered entity for a violation of this act is eliminated if common law causes of action are permitted to be brought forward by class action plaintiffs, undermining one of the core premises of this language, or of the bill. I understand that there are lots of discussions taking place. I will withdraw this amendment today, but intend to work hard to make sure that this language is modified before this legislation moves forward to full committee. And with that, I withdraw the offer of this amendment.
Without objection, the amendment is withdrawn. The chair wishes to thank the gentleman for bringing this to our attention and his willingness to work with the subcommittee staff. Are there further amendments?
Mr. Chairman,
Gentlelady
I have
is
an amendment
recognized.
at the desk.
Clerk will report.
This is the PI rule.
Amendment to the discussion draft offered by Ms. Clark.
Without objection, the reading of the amendment is dispensed with, and gentlelady is recognized for 5 minutes in support of her amendment.
I thank you, Mr. Chairman. The draft bill includes a limited and finite list of types of information that is personal information. Only the types of information in that short list are required to be secured under the data security section of the bill. And for there to be a requirement that any consumer ever hear about their personal information being breached, that information has to fit within the bill's definition of personal information and be related to the identity theft or financial harm. I think that the bill's definition of personal information is far too limited. It does not cover, for example, health information or geolocation or other types of information currently covered under some state laws. And even if we agreed that the list of what is personal information be limited to those data related to identity theft or financial harm, the definition in the bill is still too narrow. As we have seen, the methods of hacking change and adapt as some holes are plugged and criminals become more sophisticated. The types of information that is valuable for identity theft changes over time. With the recent breaches of the Anthem and Primera, we are learning that health and medical information are becoming more valuable to criminals than credit card information. And as I said, health and medical information is not covered by the draft bill. So as we have heard throughout this subcommittee's hearings on this subject, the data security and breach notification law must be flexible and adaptable. The amendment I am offering today will provide the FTC with rulemaking authority to change the definition of personal information as needed. We have heard that this bill is narrowly targeted to protect the information it is valuable to criminals, but that changes over time, and the enforcers must be able to change with it. With that, Mr. Chairman, I yield back.
Gentlelady yields back. Is there anyone seeking discussion of the amendment? Well, the chair will recognize himself first, if that's all right. The draft legislation that is recognized myself for 5 minutes. The draft legislation clearly defines what is considered personal information without ceding unnecessary authority to the Federal Trade Commission to expand that definition. Nothing in the draft takes away Congress's ability to change the definition of personal information. Nothing takes away the Federal Trade Commission's existing authority, its ability to obtain injunctions, consent decrees, or investigate unfair or deceptive trade practices. That remains untouched and is outside the scope of this bill. I will yield to the gentlelady from Illinois.
Good going to give me my own, yeah, okay. Before I comment on this amendment, I just want to point out for the record that at our last hearing, Mr. Johnson of the Federal Communications Commission and Laura Moy of the Open Technology Institute testified very differently what counsel responded to Mr. Welch regarding the FCC requirements to secure information such as viewing habits and maintaining consumer privacy. I wanted to make sure that disagreement at least was registered. But regarding the Clark Amendment, I want to strongly support it. The legislation lists specific types of information as personal and subject to the terms of the bill. Not included in those terms are new and evolving forms of information, geolocation, where you are, and information not completely covered by other data protection laws, such as health information. This amendment would address those shortcomings by providing the FTC with the rulemaking authority needed to amend and enhance the definition of personal information as needed to adequately protect consumer data. Geolocation information can be used to pinpoint the location of individual, his or her regular movement patterns, and home address, among other information. And as I said last week, no one would have thought to include geolocation in the definition of personal information just a few years ago. In fact, the committee did not include geolocation data when the House passed the Data Act in 2009. The states are increasingly considering geolocation data as personal in nature. Recently introduced legislation in Illinois would require businesses to notify consumers if geolocation information is breached. I don't know, and none of us knows, what the future of data will hold, or whether and how that data could be used to identify any individual. That's one reason why we need to provide the FTC with that authority. Health information might also be used to identify an individual, and more importantly, access to that information by an unauthorized source could lead to financial or other types of harm. The Health Insurance Portability and Accountability Act, HIPAA, protects data collected by healthcare providers, health plans, and other entities that process health insurance claims, as well as contractors, subcontractors for those entities. But HIPAA does not cover over-the-counter drugs, internet searches for health data, medical-related social networks, purchases of health-related products through online retailers, or retail store preferences and locations. Recognizing that vulnerability, states including Florida and Texas, have included health-related information as protected personal information under their consumer protection statutes. The FTC has the expertise to ensure that gaps in HIPAA can be addressed by this legislation through a rulemaking process. I think that these two examples make clear that the FTC must have the authority to amend the definition of personal information, and I would urge my colleagues to support this amendment. I yield back.
Gentlelady yields back. Anyone seeking further time? Gentleman from New Jersey is recognized.
Thank you, Mr. Chairman. I support the amendment from the gentlewoman from New York. One of the biggest flaws in this draft bill is the definition of personal information. The current definition will limit the protections to a narrow set of information while preempting stronger state laws that contain more robust definitions of personal information. This bill does not require protection of health or email and password combinations, both of which are protected by some state laws. In addition to displacing stronger state laws, such a narrow definition actually could hurt current efforts to curb data breaches. Enforcement actions have already been brought based on companies' failures to properly protect consumers' personal information, such as payroll information, employer histories, health information, mortgage information, email addresses, income histories, book and music purchase information, tax returns, and more. None of these kinds of personal information would be covered by this bill. and a breach of these kinds of information, which could lead to devastating effects for the people whose information is stolen, would not be subject to enforcement for either a failure of security or failure to notify. Another issue here is what will be considered personal information in the future. This committee has been working on data breach legislation for years now, and in that time, the types of information that is considered personal information has evolved. Biometric data, for example, was not considered just a few years ago. But as technology changes and criminals get more sophisticated, so do the types of personal information that should be protected, and this bill should be flexible enough to allow for changes over time. So I support this amendment because it gives the Federal Trade Commission rulemaking authority to change the definition of personal information over time and to develop and adjust with the needs of the times. I urge my colleagues to support the Clark amendment, and I yield back.
Gentleman yields back. Does anyone seek further time on the amendment? If not, the vote occurs on the amendment. All those in favor shall signify by saying aye.
Aye.
Roll call, Mr. Chairman.
All those opposed, nay. Nay. The nays appear to have it. Gentleman is recognized. The gentleman wish a roll call vote? Clerk will report.
Mr. Lance? Mr. Lance votes no. Mrs. Blackburn? Ms. Blackburn votes no. Mr. Harper? Mr. Harper votes no. Mr. Guthrie? Mr. Guthrie votes no. Mr. Olson? Mr. Olson votes no. Mr. Pompeo? Mr. Pompeo votes no. Mr. Kinzinger? Mr. Kinzinger votes no. Mr. Bilirakis? Mr. Bilirakis votes no. Ms. Brooks? Ms. Brooks votes no. Mr. Mullen? Mr. Mullen votes no. Chairman Upton? Chairman Upton votes no. Ms. Schakowsky? Ms. Schakowsky votes aye. Ms. Clark? Ms. Clark votes aye. Mr. Kennedy? Mr. Kennedy votes aye. Mr. Cardenas? Mr. Cardenas votes aye. Mr. Rush? Mr. Rush votes aye. Mr. Butterfield? Mr. Welch? Mr. Pallone? Mr. Pallone votes aye. Chairman Burgess?
Chair votes no.
Chairman Burgess votes no.
Does any member wish to change their vote? The clerk will report the result.
Mr. Chairman, on that vote, there were 7 ayes and 12 nays.
The amendment is not agreed to. Are there further amendments?
Chairman,
Gentlemen, for what purposes, the gentleman for
Mr. Chairman, I have an
From Illinois
amendment at the desk,
recognition, the clerk will report.
001, concurrent jurisdiction.
Congressman, is it the provider amendment or the carrier amendment?
This is the carrier amendment. It's
Amendment to discussion draft offered by Mr. Rush.
right.
Without objection, the reading of the amendment is dispensed with, and the gentleman is recognized for
Provide
5 minutes in support of his amendment.
Thank you, Mr. Chairman. Mr. Chairman, if this draft bill were enacted, regulatory and enforcement authority over data security and breach notification currently granted to the FCC under certain sections of the Communications Act and its regulations will have absolutely no force or effect. The data security and breach notification protections under the Communications Act are broader than the protections afforded under this draft. The Communications Act provides security protections for information regarding the telecommunications and VoIP subscribers' use of the service. But this draft does not provide security protections for all of that information. In addition, the Communications Act provides security protections for information regarding cable and satellite subscriber services and use of those services. This draft does not provide security protections for any of that information. This draft bill also voids breach notification obligations under the Communications Act and its regulations. Mr. Chairman, my amendment was simply delete Section 6C of the draft bill and allow the FCC to continue to regulate data security and breach notification for providers of telecommunications, VoIP, cable, and satellite services. My amendment further ensures that carriers will not have notice obligations under both the FTC and the FCC. If a carrier provided notice of a breach under this bill, it would not have to provide notice under the Communications Act. With that, Mr. Chairman, I ask that my amendment receive an affirmative vote by the members of this subcommittee, and I yield back the balance of my time.
Gentleman yields back. The chair will recognize himself 5 minutes for the purposes of striking the last word. So the draft before us today is not a privacy draft. It does nothing to preempt privacy, but it is not a privacy draft. And just to reiterate, the scope of the bill is limited to information that is directly tied to identity theft and financial fraud. Federal law exists addressing the privacy of users and their viewing habits in the Video Privacy Protection Act. That act, the Video Privacy Protection Act, regulates when a company like Netflix can allow their users to share their viewing history. And over-the-top video providers such as Netflix or Hulu cannot share a user's viewing history without their express consent. This issue is a perfect example of a privacy statute that deals directly with permissible uses of an individual's information that is directly outside the scope of this draft for discussion before the subcommittee. To the extent that there are concerns about the scope of the Video Privacy Protection Act, those concerns are best dealt with in legislation that would be considered by the Judiciary Committee, Telecom Subcommittee. I will yield back my time and ask.
Chairman, Mr. Chairman, I just respectfully disagree with you. I think that what we have now, if this bill were to pass, then what you, in effect, what you would be doing is preventing the FCC from enforcement of its now provisions for privacy. With this bill, we're already, you seem to maintain that this is not a privacy bill. But if this bill passed as it is, then this bill steps right into the middle of the privacy guarantees and the privacy authorities that the FCC currently have. So there's no way to say, well, this is not a privacy matter. Privacy is not a topic of this discussion. And at the same time, you are preventing the stated authority and the current authority that the FCC currently have as it relates to enforcement of privacy. So you're in the middle of it. There's no way out of it. You're in the middle of it. We're
Reclaiming my time, and the gentleman's objections are noted. It's unclear how his amendment improves the consumer protections in the bill. Under our definition, the carriers are required to safeguard the information, including the number dialed, the number from which a call was placed, and the time and duration of calls. I'll yield back my time and recognize the gentlelady from Illinois seeks.
Well,
What purposes does the lady from Illinois seek recognition?
to strike the last word, please.
Gentlelady's recognized.
I want to first thank Mr. Rush because he has been working on this kind of legislation for many years now in conjunction with the former chairman of the committee, Joe Barton, and I support his amendment. The bill would move authority over telecommunications, voice over internet protocol, VoIP, satellite and cable data security, and breach notification from the FCC to the FTC. But in doing so, FCC regulatory and enforcement authority under certain sections of the Communications Act would have no force or effect. The Communications Act provides security protections for information regarding telecommunications, VoIP, cable, and satellite subscribers' use of the service, but this bill does not provide security protections for all of that information. It covers only, quote, the location of, number from which and to which a call is placed, and the time and duration of such call, unquote. As Mr. Johnson of the FCC testified last week, the number of calls a person has made, peak calling periods, the time of day the calls are typically made, call waiting or caller ID services, financial status of account holders, federal assistance programs in which the customers are enrolled, TV shows watched on cable would not be protected under the bill. This amendment is simple. It maintains FCC's existing authority to protect telecommunications, VoIP, cable, and satellite customers as it currently does. The rest of the bill and its authorities would remain intact. I urge my colleagues to support this amendment, and I yield back.
Would the gentlelady yield? The
I'd be
ranking
happy-
member, will you yield?
I would be happy to yield to Mr. Rush.
Yeah, thank you for yielding. I want to ask the alleged counsel a question. Do you have an interpretation of the discussion draft's effect on the FCC's authority to exercise its privacy regulations under the Communications Act?
Mr. Congressman, the language of the draft legislation, specifically Section 6C, designates that the scope of the regulations listed are actually limited to data security and breach notification requirements, as opposed to any other requirements in those sections, and preserves the FCC's authority under those sections.
Are you saying then only in respect to data security, do you have any language or any information or have there been any discussion about viewing habits?
In regards to viewing habits, the interpretation that has been given in these instances, there's one case that we're aware of where viewing habits for information that was contained in a set-top box was not considered personal information under the CP&I rules, and that is our understanding of the scope.
Chair thanks the gentleman. Gentleman yields back. Further discussion on the amendment. The gentleman from New Jersey is recognized. All right, did the gentleman from New Jersey seek to strike the last word?
Yes.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. And I want to speak in support of the amendment from the gentleman from Illinois. While we've heard that the purpose of this draft bill is to ensure uniformity of standards for data security and breach notification, the preemption with certain provisions of the Communications Act and associated regulations in Section 6C goes against that purpose, in my opinion. Currently, the Communications Act includes a number of provisions that place obligations on telecommunications, VoIP, satellite, and cable service providers to protect consumer information from disclosure, and this includes viewing history, on-demand purchases, IP addresses, Medicaid SNAP status, how many calls made to a certain number, customer future preferences, locations, and passwords. The customer information protected by Sections 201, 202, 222, 338, and 631 of the Communications Act would no longer have to be protected if this bill becomes law, and carriers would no longer be obligated to notify consumers if that info is compromised. Furthermore, this bill could hamper FCC's privacy portfolio. While I appreciate the effort in Section 6C to limit the preemption to data security and breach notification only, instead of also preempting all privacy protections in the Communications Act, we have heard from the FCC itself that separating data security from privacy is virtually impossible. If the bill passes, the FCC will continue to require carriers to get consent before sharing customer information, but the FTC, in enforcing the security provisions of this Act, would not be allowed to require that info to be secured, leaving the info exposed to be shared with anyone. I also want to point out that this amendment does not remove the provisions of the bill that gives the FTC authority to enforce this bill against common carriers. Instead of weakening protections, this amendment would put 2 cops on the beat and ultimately strengthen consumer safeguards. And as I've said repeatedly, Mr. Chairman, our goal for legislation should always be putting people in a better place than they are today. Weakening the protections over the personal information of telecommunications, VoIP, satellite, and cable subscribers does not meet that goal. And therefore, I support the Rush Amendment to strike this preemption from the bill to ensure that consumers and their personal information continues to be properly protected. And I would yield back.
Gentleman yields back. Further discussion on the amendment? Seeing none, the vote occurs on the amendment. All those in favor shall signify by saying aye. Aye. Those opposed, nay. Nay. There is a request for a roll call vote. Clerk will call a roll.
Mr. Lance? No. Mr. Lance votes no. Ms. Blackburn? Ms. Blackburn votes no. Mr. Harper? Mr. Guthrie? Mr. Guthrie votes no. Mr. Olson? Mr. Olson votes no. Mr. Pompeo? Mr. Pompeo votes no. Mr. Kinzinger? Mr. Kinzinger votes no. Mr. Bilirakis? Mr. Bilirakis votes no. Ms. Brooks? Ms. Brooks votes no. Mr. Mullen? Mr. Mullen votes no. Chairman Upton? No. Chairman Upton votes no. Ms. Schakowsky? Ms. Schakowsky votes aye. Ms. Clark? Ms. Clark votes aye. Mr. Kennedy? Mr. Kennedy votes aye. Mr. Cardenas? Mr. Cardenas votes aye. Mr. Rush? Mr. Rush votes aye. Mr. Butterfield? Mr. Welch? Mr. Welch votes aye. Mr. Pallone? Mr. Pallone votes aye. Chairman Burgess?
No.
Chairman Burgess votes no.
The clerk will report. Is there any other member seeking to vote?
Mr. Harper votes no.
Any member wish to change their vote? The clerk will report the result.
Mr. Chairman, on that vote, there were 7 ayes and 12 nays.
The amendment is not agreed to. Further amendments?
Mr. Chairman. Mr.
For
Chairman.
what purposes the gentleman from Illinois seek recognition?
Mr. Chairman, I have an amendment, and that's 01 on the carrier.
The clerk will report.
It's the data security standards. Provider, I'm sorry. Data security standards.
For 5 minutes.
Well, this amendment is a simple amendment. It really gets us to the place that's been promised by the majority. This bill preempts several sections of the Communications Act with regard to data security and breach notification. The authors of the bill have stated that the bill will continue to ensure data security and breach notification requirements for providers of telecommunications, VoIP, cable, and satellite providers. Unfortunately, Mr. Chairman, as we have clarified at the subcommittee hearing held on last week, the bill only requires security of the information defined as personal information under the bill, and not all the information that is currently required to be secured under the Communications Act. The hearing also confirmed that when there is a breach, carriers would not have to provide notice under this bill. This amendment simply requires that all information currently required to be protected under the Communications Act will now be required to be protected under this bill. And notice will have to be provided in the event of a breach, as it is now required under the Communications Act. And Mr. Chairman, just to list some of the information that is now required to be provided, that will not be provided under this bill, we have proprietary information of and related to other telecommunications carriers or providers of interconnected VoIP services, equipment managers and customers, including telecommunications carriers or providers of interconnected VoIP service, reselling telecommunications services or interconnected VoIP services provided by the telecommunication carrier or provider of interconnected VoIP service. Information that relates to the quantity, technical configuration, type, destination, location, and amount of use of telecommunication services or interconnected VoIP services by any customer of a telecommunication provider of interconnected VoIP services. And in the case of information in electronic form maintained by a cable operator or satellite carrier, personally identifiable information concerning any subscriber to a cable service, satellite services, or any other wire or radio communication service providers using any of the facilities of a cable operator or satellite carrier that are using the provision of cable or satellite services, and on and on and on and on and on and on ad infinitum. So, Mr. Chairman, at the end of the day, if this bill, if my amendment is not adopted, we have left the American consumer open, not protected at all. And I'm certain that that is not the intention of the authors of this bill. So, Mr. Chairman, in all humility and humbleness, and thinking in terms of what is best for the American consumer, I would ask that this bill, my amendment, be passed. And I yield back the balance of my time based on.
The gentleman yields back. Chair thanks the gentleman. Does anyone on the Republican side seek time in opposition? If not, I'll strike the requisite number of words and recognize myself for 5 minutes, acknowledging that this amendment amends the Communications Act significantly. The amendment also imposes breach notification obligations on service providers, even as they act as transmission facilities for those who send and receive information. The service provider structure in the bipartisan draft is the same as the structure that was proposed by Congressman Rush and Congressman Barton in H.R. 580 in the 114th Congress, and last Congress by Representative Blackburn in the Secure IT Act and a bill drafted by Senator Toomey. This is a bipartisan group of legislators tackling the challenging situation with a very similar approach. I am unclear on what the immediate concern is regarding the approach in this draft bill, and I believe it makes sense given that the engineering and policy realities. During transmission, we should not be requiring broadband providers to monitor data as it traverses their networks so that they can identify breach victims. Actually, the implications of them doing that, to me, are quite problematic. I will yield back my time and ask for the gentlelady, for what purpose does the gentlelady from Illinois seek recognition?
I seek to strike the last word.
The gentlelady is recognized for 5 minutes.
So the last amendment offered by Mr. Rush presented an option to maintain existing consumer data security and breach notification protections at the Federal Communications Commission. If the majority will not accept that proposal, I hope you will reconsider, Mr. Chairman and members, accepting this one, that you'll accept this one. The amendment would ensure that as data security and breach notification authority over telecommunications, voice over VoIP, cable, satellite provider shifts from FCC to FTC, it brings with it all existing FCC requirements. The list of data that is currently protected at the FCC but would not be protected by the FTC as the bill is currently drafted, Mr. Rush named some, and the number of calls a person makes, peak calling periods, call waiting or caller ID services, financial status of account holders, federal assistance programs in which customers are enrolled, and TV shows watched on cable. And as I said last week, I'm not overly concerned about whether the FTC or the FCC has the authority here, just that consumers are adequately protected. This addresses the same issues as the last amendment, but does so in a way that allows the Federal Trade Commission to be in charge. I would urge my colleagues to support this amendment, and I yield back.
Gentlelady yields back. Further discussion on the amendment? If not, the vote then occurs. Oh, I beg your pardon. For what purpose is the gentleman from New Jersey?
Strike the last word. I'll be brief, Mr. Chairman.
Gentleman is recognized for 5 minutes.
I just want to say, obviously, I support the gentleman from Illinois' amendment. And as Ms. Schakowsky said, the majority did not accept giving authority to the FTC to enforce this bill against common carriers while protecting the authority of the FCC to regulate and enforce their own laws and regulations, ultimately putting two cops on the beat. So let's just actually do what they say they aim to do and give the FTC the authority to enforce all the security and notification protections that currently exist under the Communications Act and associated regulations. The Rush Amendment also ensures that all of that information must be protected under the security requirements of Section 2, and the customers must be notified of a breach under the same circumstances as other personal information. And it adds language that ensures that the FTC can use its full authority to take action against telecommunications, satellite, and cable operators when necessary. We've heard that the intent of the bill is simply to move these protections from one agency to another and not to weaken customer protection, and the Rush Amendment ensures that that intent is realized. I yield back. I yield to the gentleman from Illinois.
I want to thank you for yielding. Mr. Chairman, in your opposition, you indicated that the intent of this bill is to amend the Communications Act, and that's just a mischaracterization of the intent of this bill. This bill has nothing to do with the committee.
Not the intent of the amendment. The intent of the amendment was.
The intent of the amendment
Okay.
is to amend the Communications Act, and I just wanted to clarify that the intention of this amendment is not to amend the Communications Act, but it's to amend the bill under current consideration, and not the Communications Act. And so I wanted to clarify that. You mentioned that in your opening remarks. I yield back. Thank you for yielding time.
Chair thanks the gentleman for the clarification. Gentleman yields back. Further discussion on the amendment. If there's no further discussion, the vote occurs on the amendment. The chair would just ask the ranking member if the intention is to ask for a roll call vote.
Yes.
The gentlelady requests a roll call vote. The clerk will call roll.
Mr. Lance. Mr. Lance votes no. Ms. Blackburn. Ms. Blackburn votes no. Mr. Harper. Mr. Guthrie. Mr. Guthrie votes no. Mr. Pompeo. Mr. Pompeo votes no. Mr. Olson. Mr. Olson votes no. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Bilirakis. Mr. Bilirakis votes no. Ms. Brooks. Ms. Brooks votes no. Mr. Mullen. Mr. Mullen votes no. Chairman Upton. Chairman Upton votes no. Ms. Schakowsky. Ms. Schakowsky votes yes. Ms. Clark. Ms. Clark votes yes. Mr. Kennedy. Mr. Kennedy votes yes. Mr. Cardenas. Mr. Cardenas votes yes. Mr. Rush. Mr. Rush votes yes. Mr. Butterfield. Mr. Welch. Mr. Welch votes yes. Mr. Pallone. Mr. Pallone votes yes. Chairman Burgess. Chairman Burgess votes no. Mr. Harper votes no. Mr. Chairman, on that vote, there were 7 ayes and 12 nays.
The amendment is not agreed to. Are there further amendments to the bill?
Chairman.
Gentleman from Massachusetts, for what purposes does the gentleman from Massachusetts seek recognition?
Mr. Chairman, I have an amendment at the desk. Kennedy preempt 2.
The clerk will report.
Amendment to the discussion draft offered by Mr. Kennedy.
Without objection, the reading of the amendment is dispensed with, and the gentleman is recognized for 5 minutes in support of his amendment.
Thank you very much, Mr. Chairman. Mr. Chairman, as is often the case, states have been very active in protecting consumers from data breaches. While this issue has been discussed and argued and voted on in Congress, almost all of the states have enacted breach notification legislation. In many cases, those state laws are stronger than the draft before us today. This is certainly the case for my home state in the Commonwealth of Massachusetts. I understand why some want to create a single national standard for breach notification. Reducing the burdens on businesses, particularly businesses that were the victim of criminal breaches, is a sensible and laudable goal. But we must also ensure that consumers, who are also the victim of breaches, do not lose protections that they currently have in place. Last week, we had the Assistant Attorney General from Massachusetts testify before this committee. Frankly, some of the statistics that she cited were shocking. From 2008 to July of 2014, the Massachusetts Attorney General's office received a notice of 8,665 security breaches, affecting nearly 5 million Massachusetts residents. For 2013, each breach, on average, impacted 74 Massachusetts residents. Section 6A of this bill completely preempts all state laws that relate to data security and breach notification, including all common law and state consumer protection laws as applied to data security and breach notification. I believe that preemption is far too broad. The amendment that I'm introducing today allows states to continue doing their good work in protecting consumers whose personal information is put at risk because of data breach. It allows states that have enacted data security requirements, like Massachusetts, to continue to enforce their own data security laws. But it also provides a single standard for companies to follow in the event of a breach. Notification to consumers will be unified, and businesses won't be burdened with trying to comply with 51 different breach notification laws. Further, this amendment fixes a glaring omission in the bill. This amendment helps the state attorney generals with their enforcement of federal legislation by requiring notice to state AGs. The states are strong enforcers of data security and breach notification laws. This amendment will only help them in their ongoing efforts to protect consumers to the sometimes devastating effects of data breaches. Thank you, Mr. Chairman. I yield back.
Gentleman yields back. Does anyone on the Republican side seek time in opposition? If not, the chair will...
Mr. Chairman, I strike the last word, sir.
Oh, beg your pardon. For what purpose does the gentleman from Texas seek recognition?
I move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. I do not support this amendment. Strong preemption is essential. I say again, strong preemption is essential. Right now, there are 47 different notification rules in 47 different states. We cannot create the 48 standard with this amendment. Doing so results in too many notices, which will likely be confusing to these folks we're trying to help. I appreciate the efforts to have bipartisan preemption language. I reiterate my support for the strongest language possible, but this amendment is not that. I urge my colleagues to vote against it. I yield back.
Chair, thanks. The gentleman yields back. Other people seeking time on the amendment.
Yes.
For what purpose does the gentlelady from Illinois seek recognition?
Thank you, Mr. Chairman. I'd like to strike the last word.
Gentlelady is recognized for 5 minutes.
And first, let me thank Mr. Kennedy for offering this amendment to ensure that states have the information and authority needed to continue to protect consumers. This amendment would require that states are informed in the event of a security breach impacting their citizens, and that state attorneys general are able to maintain their authority to investigate, subpoena, and pursue legal action against entities that steal or fail to protect consumer data. It provides companies with a single set of requirements to provide notice to consumers in the event of a breach, while maintaining states' ability to protect their citizens. Last year, Illinois Attorney General Lisa Madigan appeared before the subcommittee on the issue of data breach. She said that since 2006, her office had received more than 40,000 requests for assistance and have helped thousands of Illinois residents related to data breaches. Her office joined with the Connecticut Attorney General's office to lead the multi-state investigation into the breaches of Target, Neiman Marcus, and Michaels. Attorney General Madigan specifically asked that we not preempt Illinois law in strengthening the federal response to this issue. As she said, quote, "The states have been on the front lines of this battle for a decade," unquote. We cannot afford to lose that valuable consumer protection and insight. We need more eyes on the issue, not fewer. This amendment balances the enforcement needs of states. At the same time, it lessens burdens on businesses. Again, I would urge my colleagues to support Mr. Kennedy's amendment. And I yield to the gentleman from New Jersey.
Thank you. I just want to also urge support of the Kennedy amendment. To guarantee that consumers do not lose important safeguards, it's imperative that states have the tools necessary, and the Kennedy amendment preserves the goal of the bill, which is to ensure uniformity and notification of breaches. If a company that has suffered a breach provides notice under the provisions of this bill, that company would not have further notification requirements under state law. And the amendment also preserves state common law, including contract, tort, and consumer protection laws, and ensures that states' attorney generals are provided with notices of breaches. Most of the breaches are not the huge breaches that we hear about in the news that affect millions of people. So forcing state AGs to rely on customer complaints or news reports will constrain their ability to enforce this bill and protect the consumer. So I'd urge my colleagues to support the gentleman from Massachusetts amendment. I yield back to the gentlewoman from Illinois.
If I could ask for a brief word. Thank you. Just want to, I appreciate my colleague's comments as well in support, and my colleague who's spoken opposition to the amendment. Just to clarify, the amendment does not create an additional standard. It allows for a federal standard that would be uniform across the entire country, but allows for on notification, but then allows for states to enforce their own standards when it comes to breach of security. So it's a different. It doesn't actually add another layer on. It actually does try to allow for a bit of both. So just to clarify. Thank you. Yield back.
Gentlelady yields back. The chair thanks the gentlelady. Other members seeking time. If there's no further discussion, the vote will occur on the amendment. And the chair would ask of the gentlelady if she requests.
I would ask for a roll call vote.
The gentlelady requests a record vote. The clerk will call the roll.
Mr. Lance. Mr. Lance votes no. Ms. Blackburn. Ms. Blackburn votes no. Mr. Harper. Mr. Harper votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. Pompeo. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Bilirakis. Mr. Bilirakis votes no. Ms. Brooks. Ms. Brooks votes no. Mr. Mullen. Mr. Mullen votes no. Chairman Upton. Chairman Upton votes no. Ms. Schakowsky.
Aye.
Ms. Schakowsky votes aye. Ms. Clark. Aye. Ms. Clark votes aye. Mr. Kennedy. Aye. Mr. Kennedy votes aye. Mr. Cardenas. Aye. Mr. Cardenas votes aye. Mr. Rush. Aye. Mr. Rush votes aye. Mr. Butterfield. Mr. Welch. Aye. Mr. Welch votes aye. Mr. Pallone.
Votes aye.
Mr. Pallone votes aye. Chairman Burgess.
Votes no.
Chairman Burgess votes no.
Other members seeking to be recorded. Clerk will report the result.
Mr. Chairman, on that vote, there were 7 ayes and 11 nays.
The amendment is not agreed to. Are there further amendments to the bill?
Mr. Chairman, I have one further amendment.
For what purpose does the gentleman from Massachusetts seek recognition?
Mr. Chairman, I have an amendment at the desk. It's Kennedy Common 01.
The clerk will report the amendment.
Amendment to the discussion draft offered by Mr. Kennedy.
Without objection, the reading of the amendment is dispensed with, and the gentleman is recognized for 5 minutes.
Thank you,
in support
Mr.
of his
Chairman.
amendment.
Thank you, Mr. Chairman. I apologize. And at the risk of repeating myself, I will try to be brief. While my previous amendment was voted down, the preemption language in this bill still needs to be fixed. Section 6B of the discussion draft seems to reflect the intent to preserve state common law. However, as I just noted, the language in Section 6A plainly preempts state common law. The terms, quote, rule, requirement, and, quote, other provision having the force and effect of law, end quote, have been held to encompass common law. Section 6A and 6B are directly in conflict with each other. I don't believe anyone in the subcommittee should vote on a draft that is internally inconsistent. I've introduced this amendment to correct this error and to clarify that state common law, including any state consumer protection law, any state law that are relating to acts of fraud or deception, and any state trespass, contract, or tort law not be preempted. Again, Massachusetts is a leader in consumer protection, and it would be a grave mistake for Congress to remove the important tools at the disposal of our state's Attorney General. Without some fix for this conflicting language, the preemption provision will be open for unnecessary litigation and ultimately left to judicial interpretation, which may not reflect the intent of the drafters. We should endeavor to minimize inconsistencies and lessen the need for litigation where possible. And again, we must ensure that federal legislation does not weaken protections for consumers. I urge my colleagues to support this amendment, and I yield back the balance of my time.
Gentleman yields back. If anyone seeking time to speak on the amendment, I will move to strike the requisite number of words. And I was going to speak in opposition, if that is okay with the ranking member of the full committee. I move to strike the last word and recognize myself for 5 minutes in opposition. And again, the question on preemption is one that indeed the subcommittee has studied and heard testimony by our witnesses in both the general hearing and the legislative hearing. Preemption is important for both consumers and businesses who are both victims of criminal data breaches. And there does seem to be bipartisan agreement that state laws that deal specifically with breach notification should be preempted. For businesses, there are 51 different state and territory regimes for breach notification. I would also like to call attention to that all of the consumer protections that are in this bill for consumers relative to the significant data breaches and the data that criminals can monetize. Council has some bar graphs that show how consumers across the nation actually will be better protected and better served under this bill. The bright green bar representing the data protection or the consumer protections that are included in the draft Blackburn-Welch legislation that we're considering today. If other members wish to peruse the bar graphs, I'll make them available to them, but if not, I will yield back my time.
Mr. Chairman, if I may, could add in Massachusetts there, we'd like to see how much higher it would go.
Absolutely is. Further discussion on the amendment. The chair, floor person, the gentlelady from Illinois, seek recognition.
To strike the last word, Mr. Chairman.
Gentlelady is recognized for 5 minutes.
The chart's kind of hard to follow, but I do want to say that we're not limited in the amount that we can protect consumers, and I believe, and I think on this side we believe that our amendments actually added to the protection of consumers, and that our graph would be actually off the charts. I support the Kennedy amendment. Last week, for example, Mr. Welch made clear that he wants this bill to maintain the common law protections consumers currently have, and this discussion draft was conflicted over the preemption over common law. Mr. Pompeo's amendment attempted to address that issue, eliminating the language that saying that the bill shall not exempt a covered entity from liability under common law. I appreciate the fact that that was withdrawn, and I hope that it will not be reintroduced. Under Section 1, the bill explicitly states that one of the purposes of the legislation is to preempt common law. That portion is bracketed, meaning that it is subject to future negotiations. And Section 6A completely preempts all state laws that specifically address data security or breach notification. That includes common law. This amendment would ensure that common law protections are maintained. Those protections include state laws prohibiting fraud and deception, as well as contract and tort law. The preemption of common law would leave consumers without the protection they currently have, replacing those standards with weaker and more limited federal rules. This subcommittee should not send a bill to the full committee that would blow a hole through existing common law protections the public deserves in addressing data security and breach notification. This amendment would make sure that we don't. I encourage my colleagues to support Mr. Kennedy's common sense improvement to the bill, and I yield back.
Other members seeking recognition? Gentleman from New Jersey, for what purpose the gentleman from New Jersey?
Strike the last word in support of the Kennedy amendment.
Gentleman is recognized for 5 minutes.
I just wanted to say to the Republican counsel that when he was holding up those charts, it reminded me of a time long ago when I had to put the chart in front and in back of me and walk around like advertising. I got paid once to do that. I can't remember when. But I won't ask you to do that. I promise you. I promise you that. The Kennedy Amendment should be supported by everyone today. It corrects conflicting language in the bill and ensures common law is protected. This amendment leaves in place the language that preempts the 51 data security and breach notification laws at the state and territory level. While opinions differ about state preemption, I understand the interest in creating uniform federal standards for data security and breach notification. However, when doing so, we must ensure that the states who are charged with enforcing this legislation are not overly limited by inconsistent and unworkable statutory language. Section 6 of the bill is unclear and impractical for state AGs in its current form. Such Sections 6A and 6B are patently contradictory, in my opinion, and Section 6A completely preempts all state laws that specifically address data security or breach notification, as well as rules, standards, or other provisions that address data security or breach notification. The U.S. Supreme Court has concluded terms rule, standard, and other provisions having the force and effect of law encompass common law. Common law is law derived from judicial decisions, including much of contract and tort law. Section 6B, on the other hand, purports to preserve state common law. Apparently, the sponsors of this bill have not yet come to an agreement on the scope of the preemption. Either way, the language in the bill does not work. Moreover, preemption of common law is overly broad. This bill already preempts stronger state laws and replaces them with weaker standards. Having said that, if the purpose of the bill is to create uniform standards, even weaker standards, preemption of common law is not necessary and only serves to further weaken protections for consumers and businesses who have disputes with each other. So I would urge my colleagues to support the Kennedy Amendment. I yield back.
Chair, thanks the gentleman.
Mr. Chairman, Mr. Chairman,
For what purpose does the gentleman from Illinois seek recognition?
we'll strike the last word.
Gentleman recognized for 5 minutes.
Mr. Chairman, I'm not a lawyer, but I do understand contradictions. And I think we're talking about two. Well, first of all, Mr. Chairman, I don't know how you all will get us through the contradictions that are obvious to anybody in Section 6A and 6B. I don't understand how you're going to resolve those apparent in-your-face contradictions, but between now and full committee, I hope that you will at least try to eliminate the contradictions or deal with the contradictions. But in regards to the Kennedy Amendment, I think that we are discussing two different things. This amendment is not about creating a 48th standard. It seems to me that there is an ability to sue for data breach under state tort, trespass, or contract law, and I readily admit I'm not a lawyer. And that is different and distinctive from statutory or regulatory notice or breach requirements under the state. And so I just wanted to make sure that we can get some kind of reasoning, some kind of understanding of really what we are trying to do here with this bill. And there's much work to be done between now and full committee on this bill, as you can obviously see. And so, Mr. Chairman, I'm definitely in support of the Kennedy Amendment. I think the Kennedy Amendment takes us a long way. And absent the Kennedy Amendment, I think the bill is full of holes and full of contradictions and full of ill-conceived intentions. So with that, I yield back the balance of my time.
The chair appreciates the gentleman's concern. The gentleman yields back the balance of his time. Further discussion on the amendment. Gentleman from Vermont, for what purpose the gentleman from Vermont seek recognition?
I move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you very much, Mr. Chairman. I want to make a couple of comments about the bill and the amendment. First, I want to acknowledge the good job, from my perspective, that you've done by doing two things. One, making the bill narrow. Number two, building on the foundation of the work that was done by Congressman Rush and Congressman Barton. And I think that that has resulted in what I regard as a very practical, helpful bill. Second, you were very accommodating to many of the concerns I expressed when I was working with you and Congresswoman Blackburn, and thank you for that. Third, what I've appreciated about this approach is that we're actually trying to legislate here and listen to one another with respect to how we can improve this bill. And we've got some time between this committee markup and the full committee. I do think many of the amendments that have been offered by my colleagues, Congressman Rush, Congresswoman Clark, and Congressman Kennedy, have merit. And my hope is that you will continue this open approach that you've had in your work on this bill thus far with our leaders on our side, Ms. Schakowsky and Mr. Pallone, to see whether there might be some additional improvements that can be made, as well as working on the language that Mr. Pompeo has offered in his amendment to make certain that we get that as right as we can. So as you know, I'm fully supporting this bill, but I think that if there's an opportunity to make this bill even better, then I'd encourage all of us, with your leadership, working with Ms. Schakowsky and Mr. Pallone, to use the time between now and the full committee markup to see what improvements we can make. And I yield back.
The gentleman yields back. The chair appreciates the gentleman's comments and the comments on openness. Of course, we'll continue. Are there other members seeking time? If not, the vote occurs on the amendment, and the chair would ask the gentlelady if she intends to ask for a roll call vote.
Yes.
The gentlelady does request a record vote. Then the clerk will call the roll.
Mr. Lance. Mr. Lance votes no. Ms. Blackburn. Ms. Blackburn votes no. Mr. Harper. Mr. Harper votes no. Mr. Guthrie. Mr. Guthrie votes no. Mr. Olson. Mr. Olson votes no. Mr. Pompeo. Mr. Pompeo votes no. Mr. Kinzinger. Mr. Kinzinger votes no. Mr. Bilirakis. Mr. Bilirakis votes no. Ms. Brooks. Ms. Brooks votes no. Mr. Mullen. Mr. Mullen votes no. Chairman Upton. Chairman Upton votes no. Ms. Schakowsky. Ms. Schakowsky votes aye. Ms. Clark. Ms. Clark votes aye. Mr. Kennedy. Mr. Kennedy votes aye. Mr. Cardenas. Mr. Cardenas votes aye. Mr. Rush. Mr. Rush votes aye. Mr. Butterfield. Mr. Welch. Mr. Welch votes aye. Mr. Pallone. Mr. Pallone votes aye. Chairman Burgess. Chairman Burgess votes no.
Clerk will report the result.
Mr. Chairman, on that vote, there were 7 ayes and 12 nays.
The amendment is not agreed to. The chair asks if there are further amendments. Seeing none, the question now occurs on forwarding the committee print as amended to the full committee. All those, the chair would just ask the gentlelady if she's going to ask for a roll call vote. Chair asks all those in favor to say aye. Aye. All those opposed, no, nay? No. The ayes appear to have it. The ayes have it, and the bill is favorably forwarded. Without objection, the staff is authorized to make technical and conforming changes to the legislation approved by the subcommittee today, which is so ordered. Without objection, the subcommittee stands adjourned. Well, I'm going to just add to the